Today we will be talking about mortgages and deeds of trust, how to use them, when to use them, and why to use them. Hello, my name is Edwin Epperson. I am with The Sophisticated Investor, and we are helping investors like you build, protect, and preserve your family's generational wealth through investing like the banks. So today's topics of learning for Learn Lending: what is a mortgage and a deed of trust? When is each of these used? And then the advantages of becoming a lender. What is a mortgage and a deed of trust? Well, it is a type of security instrument recorded in public records. This means that anybody can go to their local county clerks in person or online and find out who owns a property and who is the lender on the property. So let's take Betty the borrower. Betty the borrower has an asset, whether she owns it today or whether she will be purchasing it at a later date. There is an asset that she's willing to pledge as collateral. That means that Larry the lender is willing to offer money on behalf of that collateral. The way this works, Larry gives Betty the money and Betty signs a promissory note. Now, the promissory note is an actual physical representation of Larry's capital. This makes it unique in the fact that the promissory note is just like cash that we use, the dollar bills. If you notice on a dollar bill, it says legal tender. Well, a promissory note is the same. It is a type of note. It's a legal tender. You can do a lot of amazing things with promissory notes. But for today's examples, we're going to cover real high levels what exactly is a mortgage and deed of trust. So the promissory note is a physical representation of Larry's capital. However, that promissory note needs something to tie it to the underlying collateral or the asset that Betty has pledged. This takes place through what is called the mortgage or the deed of trust. The mortgage or the deed of trust is the actual security instrument that ties the promissory note to the collateral. Well, what is in a mortgage and a deed of trust that allows this function to happen? The mortgage or the deed of trust in the first 2 pages will name several key players. The first will be the borrower. So here in the mortgage, we see the borrower, which is Anywhere Construction Corp. And it is organized and existing under the laws of Florida. The borrower's physical address is 1234 Main Street. And the borrower is the mortgagor under the mortgages. Just understand that in a deed of trust, the borrower will be called the trustor. In the case that the borrower is an entity, you will want to ensure that this address is where the entity is based, whether it's an actual office, whether it is the borrower's physical personal home address, if it's a single member LLC. Wherever that address is, it should be the place to where you can physically in person show up and speak with the owner of that company or owners. If this is not the case and the borrower is trying to use a PO box or a personal mailbox, just know as a lender, you can require a physical address to where they can reach out, where you can reach out and contact your borrower if necessary. The second party that is named is the lender. There are a lot of different things which we're not going to go into today, but just know that as the lender, you have the right and the ability to determine what is listed as your address. My personal recommendation is that you do not list your personal residence as a lender. Why? If something happens and you have to foreclose on your borrower, the borrower has a copy of this documentation. Therefore, the borrower knows where you physically reside. That could spell quite an interesting communication and an interesting situation between yourself and the borrower. It adds undue stress and pressure on you, and especially if you're married and you have a family, that doesn't need to be there. So as a lender, you by law are allowed to put a PO box or a personal mailbox or any other type of address that you want there for your address. Just know that as a lender, you get to make the rules. The next thing in the deed of trust or mortgage is the actual legal description. Now, there are 2 parts of a legal description. One is the court legal description, and the other is the address. Just know that if you list the address without the legal description, the borrower could subdivide the lot, and then the legal description is actually vastly different than the address. Legal description is what will be held up in court. The street address will not be. Or if you try to only have the address and then it goes into court or foreclosure or some type of litigation, you will have to pay additional capital and wait additional time to ensure that the street address that is listed is the actual legal address. So all that being said, most lenders, most attorneys, if you're hiring an attorney, which I highly recommend, will actually put the legal description as an attachment. It's seen as Exhibit A. It's the very first page following the executed mortgage or deed of trust, and that is where the legal description will be nested. The fourth component of a deed of trust or mortgage is simply the borrower's signature. This makes the entire documentation and the entire process legitimate and legal. You must have a borrower's signature, both on the mortgage and the promissory note, for this to be a legally binding document. We recommend that not only is it notarized, but it is also witnessed. If you're going through a title company and the title company is handling the closing of your loan, you can also require that the title company has a witness. It could be one of their employees that is there along with the notary to ensure that the borrower is who they say they are and that you're having the right person sign for the loan. So what is a mortgage and a deed of trust? Well, it can be sold as a security. In this case, we're talking about large lending companies that make or originate many loans in 1 month. And so what they have are all these loans, these mortgages and deeds of trust. So as you know, the mortgage and the deed of trust is a physical representation in paper of that hard tangible asset. And what they do, Larry the lender will take these promissory notes along with the deeds of trust and mortgages, and they will create a security and sell them to these large investors. I'm sure that you've seen some of these investors. So what will happen is they will create a bunch of these. They're called MBSs, mortgage-backed securities, and then they sell them to Fannie Mae, Freddie Mac, many of the other large investors. When they sell them, the investors give Larry the lender back their capital and they can continue to make loans. Now that's more on the retail side, but what about the private lending side? How does that work? They can be sold individually. So we have Larry's promissory note, $250,000 at 8% interest only. This note can be sold to an individual. Let's say Larry has a colleague. This is Deborah the doctor, and Deborah knows that Larry originates loans. She trusts Larry. She has seen his underwriting guidelines, and she believes that when Larry makes a loan with his own money, that this is a loan that she would like to buy because it's been properly vetted and underwritten. Deborah reaches out to Larry. Larry, I've got $250,000. I'd like to invest in a note. And Larry says, perfect. I have a note. Here's a $250,000 note. Specific paperwork is filled out and signed by both Larry and Deborah and recorded in public record. Larry sells the note and he gets the $250,000 back from Deborah. The third aspect, which is very interesting, is a mortgage and a deed of trust can be leveraged. So Larry the lender has this promissory note, again, $250,000 at 8% interest only. If you do the math, that means Larry is earning every month $1,666.67. Larry reaches out to investor Isaac, and Larry wants to be able to recoup some of the $250,000 back so he can make another loan. Well, investor Isaac says, I like the note. However, I'm not willing to buy it at face value. Would you consider $200,000? So Larry pledges the note, the full $250,000, for $200,000 from investor Isaac at 7%. Investor Isaac agrees, so he sends the $200,000 to Larry, and now Larry has collaterally assigned that note and mortgage to investor Isaac. Larry now has $200,000 in cash. This also means that he is now paying investor Isaac $1,166 per month. Now, if you look at the numbers, something very interesting has happened. Larry still technically has the note of $250,000. He has pledged it as collateral to investor Isaac. Investor Isaac is fully aware that he has given $200,000 for this collateralized promissory note that is worth $250,000. So he's basically invested at a discount, but he's also taken a discount on the interest. What has this created? Well, every month, Larry gets a payment of $1,666, and he pays investor Isaac $1,166. What happened to that $500? This is what we call a yield spread. Larry the lender is now able to make money on money that he now has back in his account. This is extremely powerful and allows a private investor, a private lender like yourself, to hypothecate or exponentially grow your capital utilizing other people's money. What is a mortgage and deed of trust? When is it used? Well, mortgages are used in judicial states, which go through the foreclosure process through a court. So the way this looks, Betty pays Larry every month. Betty stops paying Larry. So according to a judicial state, Betty and Larry have to go to the court to settle this dispute. Larry initiates the foreclosure process. This is an actual lawsuit. And then Betty and Larry have to hire attorneys and take the process through the court. This can take some time, but you know that you will get clean title. If you are a lender and you're loaning to another borrower who is buying a foreclosed property from Larry the lender, just know that it is imperative that you also get lender's title insurance on that property. We understand the court process, the foreclosure process. Just know that there are humans involved and mistakes can happen. So you want to ensure that you always get lender's title insurance. The borrower will get title insurance. However, the borrower's title insurance does not protect you as the lender. Lenders are entitled to their own set of lender's title insurance. With judicial states, unfortunately, it can take a long time to go through the foreclosure process. In the state of Florida, it can be on average between 6 and 9 months, all the way up to several years. This all depends on the type of borrower and the way that the loan was structured. So just be aware that if you're loaning in judicial states, the foreclosure process can take longer. There are unique ways, there are strategic ways that you can do loans and reduce that in case there is a foreclosure, but that's a topic for a different day. Also, know that in judicial states, the laws lean in favor of the borrower. So in judicial states, Betty the borrower, actually, the laws protect her more than Larry the lender. What about deeds of trust? Well, deeds of trust are used in non-judicial states, as well as there is a third party that is in place from the onset of the loan, which helps facilitate the entire foreclosure process if it were to happen. So again, we have Betty the borrower and Larry the lender. Betty is paying Larry every month. She stops paying. They will communicate with the trustee. Remember, in a deed of trust, there is a third party appointed as the trustee. Larry the lender appoints that trustee. Betty the borrower does not. Larry the lender appoints an attorney to be the trustee of that deed of trust. In the instance where Betty stops making their payments, Larry reaches out to the trustee and says, I would like to proceed forward with foreclosure. The trustee then handles that process from beginning to end all the way to reconveyance, or through the trust deed cell, the deed of trust cell, or sheriff's cell. All of those are synonymous with the process of Larry the lender selling the property after the foreclosure process. So here are some things that you will want to be aware of. As Larry the lender, you will get clean title going through one of these, going through the foreclosure process. Also, it can be very short. For instance, in the state of Texas, it can take literally 21 days for Larry the lender to receive the property back through a foreclosure. In the state of Georgia is unique in the fact that they allow you to use a mortgage or a deed of trust, and they have a third type of security instrument called a security deed. If you use the deed of trust or security deed in the state of Georgia, you can have your property back through the foreclosure process in about 45 days. In a mortgage, if you record a mortgage in the state of Georgia, you're looking at going through the judicial process, which exponentially increases the amount of time, typically can take about 6 months or longer. Also know that in non-judicial states, the laws do lean in favor of the lender, primarily in the aspect of foreclosure. The non-judicial states recognize that Larry the lender has taken a risk by loaning to Betty the borrower. Therefore, the states want to allow the lender to recoup that asset as quickly as possible. There are advantages to lending, and I want to talk about these between lending and being the borrower, because there are a lot of people that confuse the two or think that they're on equal plane. So first off, know that when you're the lender, you're making the rules. You have complete control. When you're borrowing, you own the asset, so you're not controlling the asset. and that means you have to play by somebody else's rules. As a lender, you get to mitigate and shift the risk. In any unmitigated risk, you shift to the borrower. When you are borrowing for real estate investments, you are assuming the liability, responsibility, and the risk of owning that asset. Remember, as the lender, you get the cash flow and you get to choose how that cash flow is structured. It could be principal and interest, or it could be interest only. As the borrower, you simply have to pay to play. Whatever structure the lender is willing to offer you, if you're wanting to borrow their money, you have to play by the rules. In lending, you can continue to take advantage of leverage. Remember the hypothecation scenario. As the lender, you can hypothecate those promissory notes and deeds of trust and mortgages and continue to make more loans with the same amount of capital or even other people's capital. When you're borrowing, once you borrow on that asset is, once it's leveraged. You cannot do any additional leverage for that asset until either you refinance it or sell it. Know that as a mortgage or a deed of trust is seen in the eyes of the law as a hard asset. This is extremely powerful. As a borrower, your down payment and any repairs or money that you have invested into that property, it is the highest risk money. Meaning when you buy a property, if something were to happen and the lender had to foreclose, you are completely wiped out. All of your money is gone. You will not receive anything back at closing unless the property sells in the auction for higher than all the fees due back to the lender. So education is key. Learning about lending. All of these aspects that make lending so powerful, you can learn, and it is all boils down to education. And that's something that we at the Sophisticated Investor firmly believe in. These are what makes someone a sophisticated investor, understanding and learning about these different aspects by investing in real estate through the eyes of a bank. And once you become a sophisticated investor, you are definitely on the winning side of the table. So this has been Edwin Epperson with Mortgages and Deeds of Trust, understanding the differences at a very high level. Look forward to connecting with you. If you have suggestions for additional topics or learn lending ideas, please reach out to me. I'm more than willing to include them in upcoming videos. And you can always join us every other Wednesday at 12 p.m. Eastern Standard Time as we go through a new learning lending topic and then open it up for investors like yourself to ask questions and have a discussion on that topic. God bless and make it a great rest of your week.